Welcome to Energy Law with Energy Law Prof. Today's lesson is going to be about regulation of nuclear power in the United States. Now, first of all, if you look at where nuclear power is generated, you can see that it's generated across most of the U.S., a little bit less in the West, but you can see a lot of generation stations in the East Coast and as well as in the Midwest around Chicago. Now, the basics of nuclear power regulation is that it's regulated under the Atomic Energy Act of 1954 that gives the exclusive authority to license and regulate to the Nuclear Regulatory Commission, which means as a general matter, states can't simply ban the building of a nuclear power plant. Now, the purpose of that law is stated as to encourage widespread development and use of atomic energy for peaceful purposes. So note that this isn't just an even high-handed regulatory authority. In theory, it's supposed to encourage development of nuclear energy. So to that purpose, the Nuclear Regulatory Commission licenses, inspects, and oversees all those commercial reactors as well as uranium processing and waste disposal. Basically, the full life cycle of nuclear power. So everything from mining and processing uranium to the nuclear power plant licensing, as well as to disposal of both low-level and high-level nuclear waste, and finally nuclear power plant decommissioning. Now, how well is the NRC, the Nuclear Regulatory Commission, doing in encouraging nuclear power? Well, what you can see is from this chart, which shows when power plants were built, you see in red when nuclear power plants were built. And you see that there was kind of a boom of construction in the 70s that continued into the 80s. But one thing is that after the 3 Mile Island accident in the late 70s is that the kind of financial risk that showed to building a nuclear power plant that if things went wrong could just be made worthless or actually have negative value meant that very few people planned nuclear power plants after that time. And so you see that there really isn't much in terms of nuclear power built after the early 1990s. Okay, let's talk about a case involving an approval for a nuclear power plant. Blue Ridge Environmental Defense versus Nuclear Regulatory Commission. This is in the DC Circuit in 2013. Now, the Nuclear Regulatory Commission approved a license application along with environmental impact statements. Of course, it has to follow the National Environmental Policy Act, NEPA. And it said that the risks of this new plant would be lower than for the current generation of plants. So this is what's called an AP1000 reactor. That's really a generation 3+. So that's more than a generation beyond those 3 Mile Island reactors. And the advantage of these plants is that they are designed to have passive core safety, which means that even if the power goes out, like it did in Fukushima, that the reactor core should remain cooled and safe. Petitioners here said, look, there should have been an environmental impact statement that was supplemented. So there should have been a supplementary environmental impact statement under the National Environmental Policy Act, under NEPA, after the government issued a report on Fukushima and what went wrong there. The court here says, no, look, the petitioners here are conflating those safety and environmental concerns with what the responsibilities under the environmental impact statement. So they're basically, this is really an environmental review statute. And they note also that the environmental impact statement already addresses the issues that are mentioned would be discussed by the post-Fukushima task force. Okay, now the unfortunate reality is that Westinghouse, the designer of this reactor, has since gone bankrupt. So there's been a number of problems with financial problems with getting these reactors built. And one big one prominent one is that South Carolina spent $9 billion on a nuclear power plant and ultimately just concluded they had no path to completing it, and so that $9 billion was effectively wasted. So we continue to have challenges making it economical to build nuclear power plants. Now note, there's a number of things. Obviously, cost of regulation can increase, the cost of environmental assessments can increase, but also one big challenge in the United States is that we have relatively low cost of electricity otherwise. We have low cost natural gas typically, we have low cost renewables, and it makes it hard for those base load plants that basically have to run all the time and just accept whatever whatever price they're getting to compete in that market. Okay, another final case, New Jersey Department of Environmental Protection versus the Nuclear Regulatory Commission, also from 2009. New Jersey sues the NRC, says that and remember this is not too long after the 9/11 attacks, that it should have considered the possibility of a terrorist attack before relicensing. So basically this is a nuclear power plant that's already in existence before allowing it to continue for another 20 years. Court says, look, this a terrorist attack disaster, that's not a reasonably close consequence of a relicensing decision. There have to be some boundaries to what the NRC has to consider in an environmental impact statement about relicensing, and a terrorist attack isn't reasonably close. First of all, the NRC can't prevent a terrorist attack. That's not the correct agency for that. And also, the NRC had done some analysis of this kind of scenario in a general environmental impact statement that it did with respect to all of its relicensing decisions. So there was no need for something more in this specific case.